Welcome to Solving Citizen Legal Encounters. Those of you who follow me know I was out last week. Colin covered. I really appreciate him doing that. He did an excellent job. So let's move on. The second thing I want to do is acknowledge the new members that came onto the channel and joined while I was out. I'll name you one by one at some point very soon. The third thing is this court case that we're going to be looking at today in Thurston County. Now, there's a sovereign citizen in this court. I did some background information on him before releasing this video. So this video you may have seen already, but I had to do some checking. So back in 2006, this sovereign citizen was pulled over for a traffic violation. He didn't have an ID, he didn't give up a driver's license, and he ran from the police on foot. So he was charged with driving without a license and obstructing a police officer. During court, he said the same thing. I don't want to be represented by anyone. I am myself. All of the sovereign citizen language. Now, while he was going through his trial and getting ready for trial, he attempted to serve the judge a notice of lien on the judge's property as an intimidation tactic to try to maybe hopefully get him off the case. And during his appeal, it was rejected. So his appeal didn't go anywhere. Not only that, he got in trouble again in Seattle, Washington. Now, let me show you something. Now, as you can see for his Seattle charges, it was driving with a license suspended, failure to transfer a title, obstructing public servant. So this shows a habit of his charges, number one. Number two, he had a lot of failure to appears within these hearings that went on for a while. And the city decided to dismiss it with prejudice. I'm not sure if it was a lack of evidence that was in the case or a witness didn't show up, but that's what they decided and that's what they went with. So now you see from 2006 to 2011 to the hearing you're about to see that he's not new to the sovereign citizen game. So let's check this hearing out. Let's go.
Your Honor, those were all the matters I had the opportunity to speak to at the moment. I could do a breakout room with two folks. I will highlight for the court's attention that Mr. Leonard Blatt is present in the courtroom. I briefly conversed with Mr. Blatt, and he is confident in his desire and decision to move forward today without the assistance of counsel of my office. But just highlighting for the court's attention that he's present in the courtroom, Mr. Leonard Blatt.
Okay. Is number 2 on the 2:30 calendar. Mr. Leonard Blatt, would you like to come forward? Sir, so are you Leonard Sabra Blatt?
Yes.
Okay, excellent. And did you have a chance, so you're here today for an arraignment, and the purpose, did you have a chance to speak with the public defender about your rights or what an arraignment means?
I declined to speak with him.
Okay.
Can I ask who you are?
Yes, so I am a pro tem judge. So I am pro tem Judge July Simpson, and I'm here. So I am the judge, the gentleman that was just here, Mr. Stashevsky. He was the public defender, and over here is Mr. Clark. He's the prosecutor representing the state.
Yesterday, I went to get the oaths of office and bonding information on all the judges of the court, but I didn't get yours because you weren't on the website as one of the judges. Do you have an oath of office on file?
So, so I am a pro tem or a part-time judge.
Mhm.
And so there's a variety of those judges who work to fill in for the regular judges. I have taken an oath of office. I don't know what, where they store those.
At the assessor's office.
He's lucky she's not a regular judge and he's not in another court because that question would not get answered.
So that's, you know, I was sworn in by the chief judge, but do you have, are you prepared to go forward today?
I don't even know what, I haven't seen the criminal complaint.
Okay, are we able to assist with that?
I believe we can. If I send it to Madam Clerk, could we potentially get it printed out?
So what's our printer situation? Are we still? Oh, you are good to go. Oh, fantastic. Yeah, if you could print out Mr. Blatt's paperwork.
Actually, it's just a citation. I believe the court may have that on file. However, if you don't, I can once again just send it over.
Well, what we're gonna do is I'm gonna get those printed out for you. Why don't you take a moment to look over them? The purpose of today is just to make sure that you understand the charges against you and the rights that you have. And including your right to public counsel if you qualify for it. I would strongly urge you to speak with Mr. Stashevsky. He's here today and he can advise you of your rights. I could advise you, but in case you have questions, that's your opportunity to speak with someone for purposes of today to better understand what we're doing here today.
I don't speak to the public defender because public defenders have advised me to perjure myself in court. And I suppose you've noticed I didn't stand when you came into the courtroom. It's nothing against you personally. I don't know you, but the US Supreme Court has held that physical gestures are a form of speech, and standing is a sign of respect for the court. And I have no respect for Washington courts. There's too much corruption, unprofessionalism.
You have a history of breaking the law?
And arbitrary behavior. So I don't speak with public defenders because they've advised me to perjure myself in that. In the state of Washington, if you're a man accused of anything by a woman, you're presumed guilty until proven guilty. Whereas in jurisdictions where they go by the rule of law, you're presumed innocent until proven guilty. And if you're falsely accused, for example, of domestic violence, if you actually committed the crime, you can bail out of court. And as long as you don't contact the other person, you won't go back to jail. But if you're falsely accused, I don't think I have the court's intention. If you're falsely accused, you cannot bail out because the court notifies your false accuser that you're released, and that gives her a blank check to have you arrested again. And every few weeks, the public defender comes to the jail cell and gives you the good news that you can be released as long as you perjure yourself that you committed the crime. All you have to do is sign the paper and a no contact order will be issued. And I told these people I can't certify under penalty of perjury that I committed the crime because I didn't. And the public defenders will tell you, yes, but I know you're not guilty, but all the guys get out this way. Just sign and you can go home. When you're trying to make a decision whether to plead guilty or not, you need to know how long you're going to stay in jail. But in the state of Washington, there's no longer a speedy trial right. In the court rules, now the courts can extend your stay in jail by 5 days at a time, indefinitely.
So, sir, what we're going to do at this point is I'll say for the record that we have some disagreements about the law. We have some agreements.
I have no disagreements about the law. I like the law.
Why does he have a history of coming to court?
What
My problem is that the judges of the Washington courts don't obey the law.
So, sir, what I'm going to do is I'm going to give you a chance to review the documents before you. I'm going to take a break until there are some other matters ready, and that'll give you some time to review those documents, and then I'll come back onto the bench and we'll proceed from there.
Okay, I don't know if I'm recorded on the record as saying I have no problem with the law. I pay good money to the legislatures in Olympia to pass laws for my benefit. Problem is, judges, I'm not talking about you, I don't know you, but judges in the state of Washington are free to disobey the law and flout the law. And it's like an endemic culture of corruption in the state of Washington. It's not only in the courts, it's in the law enforcement. I used to work for the Seattle Police Department, specifically the SPOG, Seattle Police Officers Guild, which is the police union. And they had me going out every day, picking up checks from businesses. And these businesses were paying money to have advertising space in a publication the police were supposed to be printing. But it was a fraud. It was white collar crime that the police were committing. And people were telling me, hey, I'm not going to pay you this year because the publication has never been published and I haven't seen it. So I would go back to headquarters and say, listen, I'm getting complaints from people that we're committing fraud, but we're the police. I keep telling them we're the police. We don't commit crimes, we fight crimes. Can I have a copy of the publication we're printing so I can show them? Well, look, we're out of copies. Well, can you tell me where they're distributed so I can pick them up and show them? Look, we pay you, right? We pay you to go pick up these checks, so why don't you just be quiet? Well, it's embarrassing when people accuse me of being part of a criminal activity. And so at this point, the police started leaving the phone booths, their panels, surrounding me, threatening to beat me up if I told anyone.
I'm just gonna take a moment. I want to express that to the extent that you've had negative interactions with our judicial system, that I am, personally appalled by that, and I and hope that that's not, the system that we are working under. I believe in our judicial system, otherwise I wouldn't be here today. Again, the purpose of today is an arraignment to ensure that you understand the charges that have been brought against you. We went ahead and printed a copy off for you to review. You've declined to speak with the public defender. So at this point, I'm going to give you some time to review the documents that we've printed out for you. Make sure that you understand that. I'm going to take a break from the bench until there's some other matters ready, and then I'll come back and we'll take up some other matters, including yours.
Okay, and I need some information about your official bond. Where is it filed and in what amount?
So let's, like I said, I'm going to take a break. Please go ahead and take a moment to review the documents, and then I'll come back and we'll readdress this matter.
I'm so glad she didn't answer that question.
Okay, I'm charged with driving with a suspended driver's license.
Sir, I'm going to take a break, and then when there are some other matters ready, I'm going to take your matter up again, including yours.
Okay.
Thank you. And there are some dismissals ready, but in the meanwhile, we can go ahead and retake up the matter of Mr. Leonard. Oh, suppose I should ask Mr. Leonard Blatt, have you had sufficient time to review the documents?
I haven't.
You have not? Or would you like more time?
On the record, I have not been served a criminal complaint, and Court Rule 2.1 requires a criminal complaint unless there's an exception. Has the prosecutor claimed any exception to the requirement of a criminal complaint?
Your Honor, the state will just note that that in the state of Washington, a law enforcement agency can indeed file a direct citation with the court, and the prosecution can go off of that.
That is correct, but Court Rule 2.1 B, subsection B, requires that the citation be signed. And what I've been handed is a citation and notice that is unsigned.
Okay.
Also, it hasn't been timely filed with the court, so I move to dismiss the case.
I note your motion. Your motion is denied. These are matters they have been put on the record. They're matters that you can raise later. What we're here for today is an arraignment. So we're just going to go through the arraignment process, and then you can go through. And so what I'm going to do first is—
The prosecutor hasn't moved to to deny my motion. He hasn't responded. You're supposed to be neutral, right? It's supposed to be an adversarial process. And the prosecutor, we don't know what his position is.
Well, let's go ahead and take the prosecutor's position. What is your position, Mr. Clark?
Yes, Your Honor, state will note that that there is a signature, is an e-signature with the officer's name and his badge number. So on those grounds, the state will stand against the dismissal.
The court rule does not provide for an e-signature. It says signed.
If you would just give me one moment, I apologize again. I recognize this is the second time I've done this. I did just get a notification that there was a message for me. So just take a moment and I will be right back with you. I'm gonna see what the message is.
Okay.
And we will retake up your matter.
All right.
Okay? Thank you, sir. All right. All right, Thurston County District Court is back in session. repeat it? All right. We are back on the record with the matter of Mr. Leonard Blatt.
Your Honor,
Yes.
just for the record, the state will note that RCW 1.80.061 states that a record or signature may not be denied its legal effect or enforceability solely because it is an electronic form. The state will also note that Court Rule 2.1B1 states that whenever a person is arrested pursuant to the statute of violation, which is punishable as a misdemeanor or gross misdemeanor, the arresting officer may serve upon the person a citation and notice to appear in court. So on all of these motions, the state will ask that on all of these purposes, the state will ask that the motion be denied.
I
So
need
previously-
I need to see the statute and see the notations on it before I can respond to that.
Absolutely.
I'd like to
we're
note
gonna-
a motion hearing for that.
So what we're going to do is we're not going to be hearing any motions today. I understand that you do have some motions. And what I'd like to invite you to do is to file those motions in writing with the court, serve a copy on the prosecutor, and then that'll be scheduled. Your motions will be scheduled for a motions calendar.
Okay, and I have an objection to the citation and complaint not being timely filed.
So that's another motion that you can file. So today, the sole purpose of today is that we're going to go through the arraignment process. So we're going to get you arraigned and we'll handle that. And then after that, you are welcome to file any motions that you would like in writing, serve them on the prosecutor, and they will be heard on a motions calendar.
Okay, and the court rules state that any appearance waives any objection to the complaint or citation and notice. So I have to withdraw my appearance.
So what we'll do is does the state have a position on that before I state what?
I'm sorry, Your Honor, position on what, Your Honor?
So you indicated that
I can restate what I said. The court rules state that when somebody appears in court, that is construed as a waiver to any objections to the citation and complaint, a citation and notice or complaint. So I have to withdraw my appearance.
So what I propose is that we note your objection and to preserve it for a future hearing, and proceed forward with the arraignment unless you would like to. That would be my suggestion.
State would agree.
Are you comfortable with proceeding with the arraignment with your?
Can you
objection
repeat?
noted?
I'm sorry, I'm not sure I understood you. Could you repeat what you said?
Yeah, so why don't we note for the record your objection to preserve your objection? And one thing that I could do is I could also step off and make sure that that will preserve your objection for you to determine what we should do. My view is that we should move forward with the arraignment, but I'm also willing to step off the bench and ensure that that right is preserved for you.
I'm sorry. So the two choices are proceed or you step off the bench?
For a moment, so that I can consult with another judge to determine.
You know, I'm really big on accountability and responsibility for one's actions. That's why I require a signature. So at some point along the line, someone's responsible for accusing me. And I also think I have a right to a judge, nothing personally against you, but I need somebody who can be held accountable for their actions. And it's easier to hold a judge accountable than a pro tem because they have an official bond on file. I'm not sure if a magistrate or pro tem does.
So pro tems, there is an oath of office on file. Pro tems are not required to file bonds, but what I think I hear you're saying is that you do have a right to request an elected judge to come hear your case. And so I do have one available who can come and step on and handle this matter for you.
Okay. Yes, I also just would like to add that the reason that bond is so important is because sitting on a bench as a judge is a potentially hazardous activity, just like driving a motor vehicle is a potentially hazardous
Sir,
activity.
I appreciate
which requires the
your
driver to have
views.
insurance. The
I
bond is
appreciate your views,
equal
sir.
to insurance for a driver.
Yes. So at this point, what I understand you to be saying is that you are expressing your request for an elected judge to hear this matter, which is your right to do. And I am going to step off the bench, and I will have an elected bench step on specifically for your matter, and we can get this proceeding on its way. Okay?
Okay.
All right, here we go. All right. All right, Thurston County District. Seated. All right, Mr. Blatt. We are, I'm going to move on to some other matters, and then once the other judge is available, we will retake up your matter.
I need to state something for the record. The prosecution has cited a statute that conflicts with the court rules. The court rules were promulgated by the Supreme Court justices in this state. The statute was promulgated by the legislature. So the court rules take precedent over statute.
So your
So that's I don't have to go to the law
your
library.
statement is noted, and sir, I'm going to ask you to sit down, and we'll recall your matter once a different judge is available.
Lucky for her, being pro term, she don't have to deal with all of that mess. So put someone on there full time that can follow him for a while.
All right, Thurston County District Court now in session. Judge Sam Meyer presiding.
You can be seated. So I'm on here just to hear one case. So Leonard Blatt, which one is Leonard Blatt? Oh, you can come on up and take a seat. So Mr. Blatt, you're here on a few things. First thing, on cause number 5A0421962, you're charged with 1 count of failure to transfer title within 45 days, 1 count of driving with license suspended in the 3rd degree, 1 count of a trip permit violation, and then there's also a trailing infraction of operating a motor vehicle without insurance. Anytime anybody is charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. You have the right to a trial by jury in the county where the crime is alleged to have committed. You have the right to hear and question witnesses called by the prosecution. You have the right to call your own witnesses on your own behalf, and I can require the attendance of your witnesses through the use of subpoena. You're presumed to be not guilty of the crime charge. You cannot be found guilty unless the prosecution proves the elements of the crime beyond a reasonable doubt, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify if you choose to do so. And finally, if you take this matter to trial and are convicted, then you would have a right to appeal to Superior Court. Did you hear those rights?
Yes.
Do you have any questions about them?
No.
Okay. As I said at the outset there, you have the right to be have an attorney appointed to represent you. Do you wish to have court-appointed counsel? Are you going to hire an attorney, or you also have the right to represent yourself if you can do that? Do you have a?
I'm not sure at this point I needed to hire counsel.
I'm sorry?
I'm not sure at this point I needed an attorney.
Okay. And then do you want to, Mr. Shashevsky, he's there from the Office of Public Defense. I can appoint his office to represent you. It may or may not be him. Is that something you're interested in, or are you going to represent yourself for a period of time? You can always readdress this issue at some point in the future. I just need to know where you're headed today.
Well, as I said, I'm not sure at this point that I need an attorney.
Okay. Well, you have the right to one. Whether we can debate whether you actually need one. It's been my experience when people are charged with a crime, they generally benefit from having one. But if at this point, based on what you said, I won't appoint an attorney at this point. But if you wish to readdress that at some point, you can do that. In terms about whether you need one, I think it's a good idea to have one, but you were going to say something?
Yes, it's been my experience that attorneys in the state of Washington advise their clients to perjure themselves in court when they're charged with domestic violence. They tell
Okay, so hang on just a second. I'm going to stop you there for a second. this case does not involve domestic violence.
But
This is
you
a
have
simple, just stop for a minute. Let me finish, please. And so, and I can't speak to your experience outside of this court. And, you know, I don't want to get previous experiences you have with an attorney or not get in the way of what we're doing here now. It's just a simple yes or no question. You whether want an attorney appointed to represent you or not. And if the answer to that's no, then we're going to proceed. And if the answer to that's yes, then I'll appoint your public defense, and then we'll go from there. Or you can hire someone. I tend to doubt that every attorney in the entire state, if any, do what you say, but you can hire an attorney of your own choice if you wish to do that.
Well,
I'm sure you
let's
could
say-
find someone.
Because
So what do you get? But what I need to know right now, I don't want to get into a philosophical discussion about what attorneys do or don't do in, you know, outside of this particular case. I just need to know whether or not you're interested in having an attorney appointed to represent you or not. And that's a yes. I'm asking you a yes or no question.
well, let's just say that because of the conduct I've witnessed by attorneys, that I boycott.
So I'm going to take that as a no, and so I won't appoint an attorney to represent you at this time. But at the same time, again, I'll tell you again, and you're probably going to get told a few times over the course of this case, you can readdress this issue if you wish to do that. So who's handling this for the state? Mr. Clark, is that you?
I am, Your
I'm going
Honor.
to swear you in. Could you raise your right hand, please?
Yes,
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. So what's going to happen here now is this is an arraignment. This is the initial court hearing where you advised of your rights, pleas of either guilty or not guilty, are entered. Condition, if a probable cause is established, then I can set conditions of release. I swore in the prosecutor because I'll take his sworn testimony, which can include hearsay and reports from others, to establish probable cause. If I'm satisfied that probable cause exists for the charge going forward, the charge will go forward. We'll set conditions of release. We'll set a court date. I'll give you a court date. And then that'll probably conclude the hearing here for today. So, Mr. You're going to say something?
Yes, I'm confused because he can be sworn in
Mhm.
under penalty of perjury, but he's not a witness to anything.
He's not.
So,
But he's what he is for the purpose of setting conditions of release. And the case is not being tried right now. And so he's not a witness, but he's the representative from the prosecuting attorney's office. He's an officer of the court. This is more of an offer of proof to show what sort of evidence would be presented if this were to proceed to trial. And again, nothing's being proven here today. It's just I want to know, and what judges do when they're setting conditions of release, if probable cause exists, if an offer of proof could be made that probable cause exists for the charge going forward. And that's what I'm going to hear from him today. And so that when he's going to say that, that's, you know, it's not going to be tried in front of me. Ultimately, if this case might eventually be tried in front of a jury, not me, but I'm just asking him to do this simply for the purpose of, again, whether I can be satisfied that probable cause exists for the charge going forward and for setting conditions of release and having the case move forward. So, Mr. Clark, go ahead.
Yes, Your Honor. On April 10th, 2025 at about 9 p.m., the officer stopped the defendant on Old Highway 99 for expired registration. At that time, the officer noted to have seen a Washington trip permit in the window that was dated November 21st, 2024. The defendant was ID'd via his Washington driver's license. A records check advised the defendant was suspended/revoked in the third degree.
In Washington State, a third degree driving while license suspended or revoked charge means you were caught driving when your license was suspended, but it was eligible to be reinstated. The most common reason for the charge is failing to pay traffic tickets, not reinstating your license after a suspension, or failing to comply with other terms of your driving privileges.
And at that time, he spoke with the defendant, who stated that he had bought his car. He had bought it for his son, bought that car for his son and never transferred it to him, as he lived in Minneapolis. And that is all. Those are the facts, Your Honor.
Okay, and so you're seeking probable cause for the trip permit and the failure to transfer title. I see the DWLS in the third and the trip permit.
Yes, Your Honor.
And
All
then-
three charges.
and the failure to transfer title?
Yes, Your Honor.
So, Mr. Blatt, I will find that probable cause exists for the charge going forward. Doesn't mean the state's proved it beyond a reasonable doubt. They'll still have to do that at trial. A plea of not guilty will be entered on your behalf.
Objection.
Okay.
There's no plea of not guilty on the record. I've not entered the plea.
No, you haven't. I have entered one on your behalf, and by your objection, you've preserved that for appeal if you wish to do that. And a not guilty plea preserves all your rights to trial, all the rights that I laid out in that recitation I gave you at the beginning. But a plea of not guilty will be entered in your behalf. I'm doing that. Your objection, I've heard
I
you.
withdraw the plea of not guilty. It is stricken from the record. Please don't give me the bum's rush. Let's do due process here instead of streamlining the process. I have some objections to the initiation of the complaint because I haven't been served a criminal complaint. The court rules require it. 2.1 subsection C requires criminal complaint before.
In courts of limited jurisdiction, in district court, complaints you can also be charged by citation by the charging officer, which has taken place in this case. That's how it got charged, with a citation. If you want a copy of that citation, we can certainly give it to you. You have it.
Yes.
So you can't. So again, I'm not quite done yet. And so again, I'm satisfied that resolves that issue. If you have issue, and clearly you have, and I'm not trying to give you the bum's rush. I'm just trying to, I am trying to get through the hearing. If you have issues, if you want to object to, entering a plea, I can ask you, are you going to enter a plea at all? If you're not going to enter a plea, then again, I think that the law supports me entering a not guilty plea in your behalf, which does preserve all your rights. And if you have issues, sometimes people attack these sorts of cases on constitutional grounds. They indicate that the licensing statutes are unconstitutional. You can do all that, but you've got to get all that stuff in writing and get it properly before the court in the form of a motion. But you can certainly do that. But the arraignment stage where we're at now is just as a preliminary stage, it's kind of the kickoff, if you want to make a football analogy. And that's where we go from here.
Okay, I understand that, and I agree with that. But I require my public servants to obey the law because I've witnessed too much flouting of the law in Washington courts.
Okay.
So yes, I have been served a citation and notice, and that is sufficient to initiate a case. The problem is it's unsigned, and Court Rule 2.1 subsection B requires that it be signed. Now, before you came into the courtroom, prosecutor cited a statute saying that it can be electronically signed, but that conflicts with the court rules, and the court rules take precedent over statute because the court rules are promulgated by the state Supreme Court, whereas the statute's promulgated by some attorneys in the legislature.
I think there's, okay, well, like say you preserve that issue.
The issue should be decided now.
What's that? No, you need to file appropriate motion and note it up for hearing. Anything else you wish to discuss?
Yes, I have some concerns about whether I'll get a fair trial. As I understand, this is supposed to be an adversarial process. But I'm being accused by a police officer who works for the plaintiff. The prosecutor represents the plaintiff. The witness against me is the plaintiff. The jury that's supposed to sit here is selected because of their demonstrated loyalty to the plaintiff by applying for a driver's license when I'm charged with not having a driver's license. So they're inherently biased to begin with. You yourself have a flag behind you that represents the plaintiff. The public defender is licensed to make a living in the plaintiff's courtroom at the pleasure of the plaintiff. I've been educated by the plaintiff, so how can I get a fair trial in a courtroom where everyone represents the plaintiff?
That argument makes no sense. But if you stay out of trouble, you won't be in the court and you won't have your thoughts about someone taking care of the plaintiff.
Well, I'm not going to do far of a deep dive into those things other than to say I don't agree with a lot of what you're saying in terms of who the plaintiff is and whether or not your ability to have a fair trial will be tainted by his job and what he's required to do, or his job and what he's required to do. But And again, I'm going to go back to if you think that by that token, I guess if you did take that to its logical extreme, no one could ever get a fair trial. I mean, people could do whatever they want. And I could say, like on that. Yeah. Well, hear me out for a second. In terms of like, just as an example of, driving while intoxicated, if I think we would all agree that that's a bad idea. And so hang on just a second. And it is illegal to do that. But if no one could ever get a fair trial because the police are involved, then it would be, no one would ever, people could just do anything they want, drive, drunk all they want, and then they don't have to worry about it because a case would get thrown out. Well, because they can't get a fair trial because the police pulled them over. And that doesn't seem to me like to be a great system. But again, I'm going to go back to where, if you have objections, if you have if you have a reason to believe that you can't get a fair trial and you can convince a judge that that's the case, then you need to, again, put all that in writing, make a motion and go forward.
Okay, and I want to make sure the court understands, I'm not an anarchist, and I'm actually glad there's a process for keeping dangerous drivers off the road.
Mhm.
Problem is, the courts have connected family court with traffic court, and there should be no connection. The family court has power to suspend people's driver's license, and there is
So
no
hang on
due
just a
process in
second.
those courts.
Can I stop you for a second? And that is, this is a common misconception. The courts don't suspend license, right? The Department of Licensing does. The court gives information to the Department of Licensing to suspend the license. And so the legislature has decided that certain instances in family law, for example, not paying child support, and that's just one example that I can think of, that would suspend your license. So in the family court, if someone doesn't pay child support, they'll tell that to DOL. And then DOL was the one who suspends the license. So it's a misnomer, but hang on just a second. And so the family court's not doing that. The legislature decided that's a reason to suspend license. And then the family court's just providing the information to DOL. So if you want to be mad about someone about that, you could probably be mad about the legislature, about the legislature for passing that law. But it's not the court that's doing that. It's the legislature that created the law. The courts are providing the information. The Department of Licensing is doing what they're required to do as administrative agency and suspend the license. So how that happened, that all happened over in the state legislature. What we're here, but doesn't have anything to do with this, believe it or not. Now, here you're just charged with, as I said, DWLS in the third, failure to transfer title, and a trip permit violation. There's also a no insurance ticket, which is about the most expensive thing. Pleas of not guilty have been entered, which you objected to, and which you can preserve that for appeal. Conditions of your continued release are: don't have any criminal law violations, don't drive without license or insurance, and make all your court dates. And I'm going to give you a court date here in a couple of minutes.
Well, I object to those conditions on the basis that the court is presuming that I'm not allowed to travel in my car.
No, I'm not presuming anything. I'm setting reasonable conditions of release based on the charge, and that's pretty much it.
You're presuming I need a license to travel.
Well, you do need a license to drive on the highway. Yes, absolutely.
Okay, well, I have a little quandary here because the court rules state that if I make an appearance, that's construed as a waiver to any objections to the criminal complaint or citation and notice.
I think you can make any objection. You can raise an objection to your citation notice anytime you want. And if you can, again, note up the motion, and again, put it in writing, supported by law, case law or statute. And if you can convince a judge, which does happen from time to time, there are defective information, there are defective citations, and you can certainly, I've seen cases overturned on appeal because they've gone through trial and then they have an ineffective or inappropriate information. It gets overturned on appeal. So you can certainly object to all that and brief all that up, and you might convince a judge. It's up to you as to whether you can convince a judge that that's worth throwing the case out. But for right now, I have found that probable cause exists for the case going forward. Those are the conditions of release, the least restrictive conditions of release that are present. I mean, I'm not going to set bail or anything like that. And that's what I expect you to comply with.
I need to state for the record that my plea as of this point is a demurrer. And I also like the clerk to note for the motion calendar, a motion hearing.
Okay, you need to, before you get we're gonna give you a pretrial date here right now, all right? It's gonna be out of maybe about 6 weeks. And then when you get a written motion together, get it in writing, then you can do that.
I'm serving to the prosecutor right now 3 motions. One is a demurrer. They're different titles.
Okay,
One is a demurrer, a demand for due process. The second one is a demand to dismiss. And the third one is a motion.
okay. You can go ahead and give that to the prosecutor, file it up here, and we'll set this for a Monday morning motion hearing. Sure.
Okay, I'm handing a copy to the prosecutor right now.
No, actually, she's not the prosecutor.
I mean,
Prosecutor's over there.
clerk?
She's the clerk.
And I'm handing a copy to the prosecutor.
So we'll set a motion for June 16th. June 16th on Monday morning. That should be plenty of time for the prosecutor to respond. And
These are you saying, would you like these cards?
so do we have, make sure we get a copy. So we have, is there just one copy of everything? And we'll give you a notice of that hearing. Yeah. And then once you get that, you're free to go.
I need to state for the record that I was able to get a copy of your oath of office, but not your official bond.
I did not, I'm not required to post a bond. I've never posted a bond.
There's a statute, and I don't have it with me right now, but it says that all employees of the county have to have official bond filed. So I'll bring that next time.
Okay. You know, I will say something here, Mr. Blatt. You know, I've been at this job since 2008, and I've never been requested to post a bond. I don't know that any of my colleagues here have. I'm not familiar with any of the judges in Washington have, which may lead to some conclusion, but and I don't know where you're getting your information, but you know, I'd be skeptical of a lot of what you perceive. Okay.
Find the statute and it is. I think the reason you might not know about it is because the state itself pays for your bond. They don't require you to pay for it.
Okay.
The reason it's important is because just as a driver has to have insurance because he potentially could get to an accident, a judge is also in a potentially hazardous occupation where people can get hurt. And that's what the bond is for.
I'm not sure what you mean by that.
It's analogous to a driver having driver's insurance.
I don't think that's true at all. What do you mean that I'm in a job where people could get hurt? What?
Of course, the only tool the state has at its disposal is violence or the threat of violence.
Are you threatening me?
No. The opposite is happening. The whole apparatus here is to threaten people. I mean, that's the only two things.
See, and again, I'm gonna, I will say this. I just think that you're, and for what it's worth, I will try. But and you're operating, and I see you've been through this quite a lot over the years, and so you know, I think some of the assumptions you're operating under, may not be accurate. I'll just leave it at that.
Well, let me
And again,
ask you, how are you going to get people into a jail cell? You're going to lure them with candy? You're going to have to bail, handle somebody. That's unwanted touching. That's violence. I'm not criticizing you for that. We want the state to have a monopoly on violence because sometimes it's needed.
But see, all right. Do you have a cell phone where you could send text reminders of court dates to?
I provided that already.
Okay, great. I didn't realize that. And so if we have it, then you'll get a text reminder of court dates. We'll see you back here on the 16th. I'm going to step off and then get it together.
All right.
Well, I guess we'll see what happens on the 16th when he comes back. You see all of that stuff he's talking, and he's talked like that, I'm sure, in every other court case he's had with the long length of records and stuff that he's had over the years. So we'll see how it goes. Let me know what you think about this video in the comments. I hope you enjoyed it. I hope the extra information was good for you, give you something else to think about. and I'll see you the next time. All right.